So by far, the most prevalent issue of the 292 exonerations, 75% of them were identified by an eyewitness. So that means that somebody just either made a mistake, or maybe there were issues with the lineups that police kind of tilted it in certain directions. That happens too. Maybe they were forced to sit down so that you couldn't see how fat he was. That happened. And also in 36% of those cases, more than one person identified the same innocent person. So it's really, eyewitness testimony is really problematic, and if there's a conviction that is only based on eyewitness identification, it's definitely something that maybe should be questioned. We've also learned, the Innocence Project has put out reforms that these factors can help ameliorate some of these factors, and they've learned that double blind identification procedures, so like you have an array of photos, and the person who's the police officer usually who's administering the array doesn't know who the suspect is, so they're not by accident pointing to the correct person they think it is, or like saying, are you sure, stuff like that. So they point to ways to take some of the flaw out of the system, but these are things that are going on. I just want to give one anecdote of one case in Massachusetts. Eric Sarsfield, he was exonerated after, I'm not even sure how long, but his identification procedure was the perpetrator left a jacket at the scene. They had him put on the jacket and sent it to the lady's house because this is the guy. So that's a problem. And also in our resources list, we have a list of especially focus on eyewitness identification if you go to our website. Another major issue is faulty science, and also alluded to this, where fingerprints, we've kind of always thought that they are totally individual. They match to the exclusion of all others. That's just not true. And the National Academy of Sciences released a report in 2009 basically going through each forensic science, from hair comparison to fingerprints to what else do they do, like dog scent analysis, things like that, and kind of went through them point by point. So none of these are based on the scientific method. These are all problems, and I mean, people are saying that there's 0 error rate, which is just not possible. And then the other issue is that examiners will go up on the stand and say that they're certain when there really is no way for them to be certain. People can falsely confess, or they can plead guilty to avoid being put to death or a really long sentence. So Brian Bakes in California, maybe you've heard of this case. He was in high school, and a schoolmate accused him of rape, and to avoid like a 50-year sentence if he went to trial, he pled out to 5 years. And then after he got out, the woman went to him and said, I'm sorry, I know I made it up. He was exonerated, and now he's being scouted by the NFL. There, snitches, another issue, police misconduct, and prosecutorial misconduct, and issues with defense attorneys. And with prosecutorial misconduct, I think it's an especially big issue because everybody is cloaked in immunity up to their ears. So.
I know that Alec is going to talk about how, and so I thought maybe I'd start with to get a sense of why you want to take on a case of either wrongfully accused or wrongfully convicted, and I think this might give you a little bit. I'm also going to tell a little bit why not, but start with the why.
Turn in a notorious murder case. The so-called West Memphis Three, convicted of murdering 3 Cub Scouts. 48 hours, Aaron Moriarty on why a judge has set them free.
It's been an absolute living hell.
A New York man who spent nearly 2 decades behind bars for murdering his parents is free this morning thanks to new evidence in his case.
Martin Tankleff is free from prison after 17 years, determined to clear his name of murder.
My arrest and conviction was a nightmare. This is a dream come true.
My name is Bill Ferguson, and my son is Ryan Ferguson.
We, the jury, find that defendant Ryan Murray Ferguson, guilty of murder in the second degree, as submitted in instruction number 11.
Even before Ryan Ferguson was convicted in 2005 of the brutal killing of newspaper sports editor Ken Heitholt in Columbia, Missouri, there were problems with the case. The only person who placed him at the scene was a high school friend, Chuck Erickson, who was picked up by police after telling friends that he dreamed of two teens had committed the murder. When interrogated, he couldn't even identify the murder weapon.
I think it was a shirt or something.
Well, I know it wasn't a shirt.
Like maybe a bungee cord.
We know for a fact that his belt was ripped off and his pants and he was strangled with his belt.
Really?
Does that ring a bell?
Not at all.
But because two men were seen the night of the murder, police pressed Erickson to tell them who he was with, and he did.
Whose idea was it?
It was Ryan's idea.
Ryan's idea.
The state calls Charles Erickson.
A year later at trial, Erickson had become a confident, convincing witness.
What did the defendant in this case, Ryan Ferguson, do?
He robbed him. He strangled him.
But there was no physical evidence to back Chuck's story.
Do you have either Ryan Ferguson's or Chuck Erickson's fingerprints at the scene?
No.
Do you have a murder weapon in this case?
Did we find the murder weapon? No.
You may call your next witness.
The prosecutor did have this witness.
Jerry Trump.
Jerry Trump, a janitor, told the court he could identify one of the young men at the crime scene.
If you see the individual, would you point to that individual, please?
Yes.
It took the jury 5 hours to reach a guilty verdict. Ferguson's father has spent the last 7 years working to undo it.
I gotta get busy. I got a lot of work to do.
Shortly after we aired our first report on 48 Hours, this woman, Christine Varner, came forward.
It's your conscience. I felt I had to do it.
Varner once managed the agency that employed Jerry Trump, the janitor who definitively ID'd Ryan at trial.
I'm thinking, how can you do that? That's not what you had said.
Varner says that shortly after the murder in 2001, Trump told her that he'd never be able to identify the men he saw by Kent's car.
But he said that the way the lighting was, I couldn't tell who was there at all.
And it's not just new evidence that has surfaced.
I like target shooting. I find it relaxing.
An attorney, Kathleen Zellner, who also saw the show, joined the fight to prove Ferguson's innocence.
Once you're convicted, the system works completely against you.
Today, Ferguson is the closest he's been to getting a new trial. In a hearing in April, both witnesses who put Ferguson behind bars said in sworn testimony and in open court that they lied. Erickson, who got a reduced sentence in return for cooperating at the original trial, said he was pressured by the police and prosecutor to name Ferguson. Jerry Trump, a convicted sex offender, admitted he couldn't identify anyone at the crime scene, and in a poignant moment told the court what he wished for now.
I'd like to have forgiveness from Ryan and his family.
Both men could face perjury charges, and their efforts may not even free Ferguson. The Missouri Attorney General stands by the conviction. The fact is, in appeals, recantations don't often carry much weight. It's now up to a judge to decide if Ryan Ferguson gets a new trial.
The day that Ryan walks out of prison, I'm going to feel as a father that I have done my job.
I hope that seen that piece particular, which I prepared just for this group here, because I'm telling you, there's so much more to this story. I mean, we've done 2 hours, I'm going to do another one this fall. That's just a little bit of the work we've done, but I think it explains why. These are by far the most satisfying stories you could possibly do when they work out well. The Ryan Ferguson case, I started on before the trial. I didn't think he'd be convicted. We have a number of people with 48 who work with me, or I work with them on these cases, and they're tedious. They take a very long time. You can put your heart in it, and the legal system works very different. You can be covering some big issue in a community, and you can uncover something, and the community immediately reacts. Well, I can assure you it doesn't work that way in the legal community. And as Lindsay said, there is a belief based on a time way before DNA that a verdict is sacrosanct, and you have 12 people and they made the right decision. And so the system, the appeal system is definitely set up against the idea of a person. And I understand, you don't want everyone in prison I know says they're innocent, so you don't want everyone to be able to get a new trial. But the fact that it is so difficult in certain states, particularly Missouri, where this particular case has taken place, is very frustrating, certainly for the person in prison, but very frustrating as a reporter. And then just quickly on 2 other reasons why this can be the most heartbreaking job in the world, too. Doug Longini's in this room, and he may not totally agree with me on this one, but we worked on this case, Crosley Green. Crosley Green lived in Sanford, Florida, which may be familiar to people who know about the Trayvon Martin case. Okay, so you may know something about that community. Crosley Green is a black man. Crosley Green was convicted of robbing and killing a white man. And when I first heard about the case, there were 2 private investigators who'd been hired to look into it, and we just decided to really kind of go along for the ride. I didn't really believe he was innocent. Really opened my eyes to so many problems with the case. It was just like a great learning experience in that sense. There were about 50 different pieces of evidence that convicted him. When we were done, it was somewhere around 48, 49 pieces of evidence out the door. All that was left was 1 small hair, but it didn't, of course, have the bulb, so it was only mitochondrial DNA that could be there. In large part because of our hour, there was a hearing to determine whether he'd get a new trial. But that 1 hair was tested, mitochondrial. It was done by the prosecution, done by the state. It was destroyed in the process. Now, the community that this man lives, Crosley Green, is very small. The families live there for years and years, and so what you probably know about mitochondrial is it just connects with your mother's DNA, and there are probably, just about everyone in town is probably somewhat connected. But it did indicate that he could not be excluded by it. And while the state took him off death row, Crosley Green is still in prison, and it haunts me. And I think about him all the time. And even though some great lawyers are working on the case, he's probably never going to get out. So if you can't handle heartbreak, that's one case not to do. And here's the other heartbreak. Kevin Cooper. Kevin Cooper was, again, black man, accused of killing 4 out of 5 members of the family. One just happened to survive. He was accused of robbing and going into his family, killed 4 people. Horrible, horrible murder. And 1 young kid, 9-year-old, survived, who at the time said, it's not a black man, it's not a black man. He wrote me this beautiful letter. And unlike most people who write you, it wasn't convoluted, it was clear. And so I said, oh my gosh, we got to do it. And all he wanted was post-conviction DNA. And they didn't allow it at the time in California. But I thought, great, I don't have to make a decision whether this guy's guilty or not, He's probably not, the DNA, we just have to get that for him. You would not believe, everything against him was falling apart. It was the most amazing, one of my favorite hours to work on. Oh my gosh, I don't think this guy did it. So when we asked the Attorney General's office whether they would do the post-conviction DNA, they said, no, this case doesn't count, this is not right. So they didn't do it, we put our hour on. And then, as sometimes happens, you put an hour on and kind of caused an uproar, and they did the post-conviction DNA. I'm sure some of you can guess what happened. It matched. And so now Kevin Cooper is second on the list to be executed in the state of California, in large part because of our work, because now the state can say, you got post-conviction DNA, what more can you ask for? And of course, I still have doubts, and so does an appeals court judge. But, you know, I don't have great faith in that. So these stories are absolutely the best, most gratifying stories you can do, and they can be the biggest heartaches that you can work on, and they can make you lose sleep at night. But Alec will still tell you how to do it. You want? How about I switch seats?
Hi. Are there any students here? Okay. Well, what we do at the Medill Innocence Project is pretty unique. We have undergraduate college students investigating real murder cases. But I think it's fair to say that it's not all that different what they do compared to what I did and what others do when I was at the Washington Post and what other investigative reporters do. I think the best way to describe what we did or what we do at the Medill Innocence Project is to tell you a little story, which is when I took over the Medill Innocence Project, I got a call one night. It was about 11 o'clock, and I was in my pajamas, which is probably more information than you need. But it was from an attorney who said, well, I think I might have a case that, you know, you might be interested in investigating involving a potentially wrongful conviction. And he said, I've got a, you know, box of documents, you know, do you want them? I said, yeah, I could be there in, you know, 5 minutes. He said, well, it's 11 o'clock at night. And I'm like, it's, you know, no problem. My theory is, you know, if somebody offers you documents in the middle of the night, you know, you take them. So he said, all right, you know, come on over. So I slipped on my jeans, got in the car, and my wife's like, where are you going, you know? So I was driving to this attorney's house, and then I got another call from another attorney. So I pulled over to the side of the road, and again, it's sort of exactly the way it was at the Washington Post. I took out my pad, and he started telling me, this other attorney, how he had a case that we should look into. And this case came to his attention. This was a professor, because he got an email, I think it was, from a retired court reporter, you know, the folks who transcribe the court proceedings. And this court reporter, while she was transcribing a murder case, was actually paying attention. And she came to the conclusion that the defendant, Donald Watkins, a Chicago man, was not guilty. And yet he was convicted of first-degree murder and sentenced, I think, 56 years for using a sawed-off shotgun to blow somebody's head off. And this case had bothered this court reporter to such a degree that even after she retired and moved from Chicago to Florida, that it was just on her mind. And finally, she told this professor back in Chicago that something needed to be done about it. So he told me about this case. And I figured that if a denizen of the criminal justice system has a real question about a case like that, it's worth looking into. So I looked into it. I decided that my students would investigate this case. We had virtually nothing other than some court records. I think the appellate records was where we started. And my students did what you all would do, is they started knocking on doors. They started tracking down sources. They put in FOIA requests. They pulled all kinds of records. And in the process, they came across some unbelievable evidence. I'll give you the short version, but one was that the defendant, Donald Watkins, prior to the shooting, the incident, he himself had been a victim of a crime. he had been shot and robbed, and when he was shot in his left arm, he had sustained permanent nerve damage, and his left arm had actually atrophied. And yet, that injury never came up at his trial. But the crime for which he was convicted of murder required that he hold a woman by the collar with one hand and with a sawed-off shotgun in the other, blow off the head of another man. And that, we concluded, based on talking to experts, would be very difficult to do if you basically have permanent nerve damage in one of those arms and it's seriously atrophied. And then the second breakthrough was there was essentially one key eyewitness. And as it was discussed earlier, oftentimes there are problems with what people see, witnesses see. In this case, the key eyewitness for the state was a known drug addict. And at trial, she said that she had not been doing drugs when the shooting occurred. So she said, you know, I saw what I saw, the guy did it. But my students tracked her down on the streets of Chicago where she was selling cigarettes for 50 cents a piece. And she told them that, in fact, she had snorted a line of heroin moments before the shooting had occurred, which, of course, could impair her judgment. So, based on all this, I called all my students into my office on a weekend, and I said, maybe we should write a story. They had such good information, and coming from the Washington Post, we don't just gather information, we publish it. But at the Medill Innocence Project, we hadn't, the history of it hadn't been one where publishing was occurring on a regular basis. But so I said to the students, what do you guys think? Should we publish? Should we write a story? And we went one by one, and they all said no. I said, nah, we don't want to do it. And they had their reasons, mostly they had midterms and social lives, things that professors don't have. But so, the first thing I said was, we're going to write a story. And I said the reason why we're going to do that is that we are not simply investigators, but we're investigative journalists. That's what I'm trying to teach them here. And it's very difficult just to gather this kind of information, as you all know. Very difficult. But it's equally difficult to take all that information and piece it together, verify it, make sure you're being fair, triple check everything, and put it all together. And we spent hours and hours and days putting all this together. In the end, we ended up with I think it was an 8,000-word story. And for all of the students in the class, it was their final class at Northwestern. It started at 3 o'clock in the afternoon and ended slightly after midnight. And we took a total of 5 minutes of a break during that entire time to make sure we had finally finished it all. We published the story on our website and got a huge amount of reaction from the criminal justice community and others. The students basically were on a media roadshow for weeks after that, and they won some awards. But the most important thing is that they brought to light a case that raised serious questions about a man's conviction for murder, and that's essentially been our model. And it's not unlike what we did at the Washington Post. So that's how we do what we do.
So, Alec, you have got me thinking that I'm sure there's a lot of challenges that you face, but maybe you could share some of the biggest impediments to investigating these kinds of cases.
Well, I think one of the challenges is time. I'm assuming for a lot of, how many working journalists are there in this room? Wow, okay, so you know exactly what I'm talking about. We spent 10 weeks on this one investigation, but to get 10 weeks to do one single story is in this day and age difficult to get. When I was at the Washington Post, I often got a year to do one story. So one of the challenges, I think, is time. It was true for the students because this wasn't their only commitment, but basically I told them that they had to make this their priority. And in fact, some students, I think, dropped almost all of their courses except for this one course to to pursue it. It became an obsession. There were several challenges, one of which I think you may be familiar with, which is obtaining what should be public documents. And in Chicago, I don't know about other municipalities, it's often difficult to get the documents. And just to illustrate that point quickly, so in this case, the family of the prisoner told us that the prisoner had this incident where he was shot. It wasn't enough for us to have the family say that. We needed the police records that confirmed that he had actually been injured in a burglary himself. So we went to the police with a FOIA saying, you know, give us the incident reports that show that Donald Watkins was shot in the left arm, sustaining this injury. The response from police the first time that we submitted the FOIA was, we don't have anything. So I told the students, submit it again. And so they said, well, we already did. I said, we'll do it again. So they submitted a second, more refined FOIA, and the police came back and said, we don't have anything on this. I said to the students, submit another FOIA. And they said, we just did two, so do it again. So they submitted a third FOIA. The third FOIA was more precise, and in that FOIA, the police acknowledged and gave us the records that showed that Donald Watkins had in fact been shot in the left arm. And it just kind of illustrates how difficult it is on some occasions to get the records that are even there. In some cases, many of these murders occurred many, many years ago. And in Chicago and other municipalities, those records are not kept after a certain point. And so it makes it very difficult in many of these cases where prisoners are claiming innocence if those records are not gettable because they've been destroyed after a certain amount of time. So that's one of the very big challenges too. Another one for us is the students are often going into rough neighborhoods. And for me, as a professor, that I'm more concerned about their safety, frankly, than anything else. And when I took over the Medill Innocence Project, I tasked the organization to find out what we can about safety for student reporters. And we searched the landscape and couldn't find any manual, if you will, for student reporters regarding student safety. As a reporter, there are such manuals for oftentimes foreign reporters who do this professionally, but we couldn't find anything for students or even for U.S. reporters. We were told in some cases that some organizations had something like this, but we never actually saw it. So I said, you know what, let's create a safety manual. So we put together an extensive safety manual for the students, on top of which they get a safety lesson from police. But it's clearly, an issue for any reporter, really, not just students when they're out in the field, because when you're knocking on doors, you don't know what's on the other side.
Aaron, this question's for you. We saw in the video, one of the people that you interviewed was the prosecutor, and I can imagine there's lots of reasons why he might not want to be on camera. So how do you get people to talk to you who may have something to hide? Musical chairs.
Every case is different. And sometimes, first, what's so amazing is you just have to ask, because I'm always amazed how often people don't talk to us. I just had that example this week, which I'm still a little bit in shock about, that there was two women were convicted of a murder, but the other main suspect, we thought he'd never talk with us, but we thought, well, let's just ask, and believe it or not, he said yes, even when he sat down. So, sometimes it sounds so obvious, you just assume somebody's going to talk, they will. Sometimes, in this particular case, and it's a sore subject, often prosecutors will talk after trial. In this case, I really have questions for him now. Because many things you learn about a case after the trial, after people feel more comfortable, after you have it, it takes some time where somebody may not have been so honest right around the trial, but then they will be honest down the road. And now, in this particular case, the prosecutor is a judge, and so he's now claiming he can't speak at all, which is, I don't know how to get around that one. And because now I have very serious questions about. There are some of the obvious things where we promise not to show their identity. If they're worried about something, we've had to do that in cases. But most of the time, it's more persistence than anything else. We worked on a case in California, Bruce Lister, who was released after 26 years. And we really wanted the prosecutor to talk. And I think, I think you have to appeal to people's sense of justice and honesty, and you have to be persistent. I really do think that's the most important thing about getting anybody to speak.
Lindsay, I guess I'm curious why you think that more reporters don't investigate wrongful convictions.
Well, if you listened to Erin earlier, that's probably a lot of the reason. I do think that a big part of it is that when people are exonerated, the stories come out and there's, the lawyer holding up the guy's hand and it's like this victorious moment and they're coming down the court steps. And then there isn't always an inquiry into, and it doesn't make it into the newspapers and into the public discourse, what actually went wrong in those cases. And I think that it seems like it's a lawyer's issue. Lawyers need to handle these DNA cases, and they mostly have, but with the Innocence Project at Brandeis and at MacDill, we're really putting the journalistic perspective to it and using those skills to investigate those cases. And I think that there's really a role for journalists in looking into them, and it's not always seen as that's what journalists should do, it should be a lawyer's thing, because really the DNA cases are such a small, tiny sliver of the potential wrongful convictions, and it will take the journalists 10 months to get to the bottom of it.
Can I add one thing on this? This is very frustrating to me, and I guess I've learned this from years of covering these cases. Sometimes we don't even realize it as journalists, that we take the prosecutor or the state's word, and we give it much more weight than we should. Boy, have I learned that over the years. And just a perfect example, I think of all the time, with Marty Tankleff, I had the benefit of hindsight. I started on the story much later, after he'd been in prison for a while, and we started hearing that there was a problem with the conviction. But we went back and looked at the earliest stories, and every story said that Marty Tankleff, I should tell you, he was a young man, 17 at the time, accused of killing his parents. He was the only child. They were very wealthy people who lived on Long Island. And the story that was put out, everything I read was, he killed his parents because he was a rebellious teenager. He wanted his money. His parents wouldn't let him do what he wanted. He wanted his money now. Every story I read back then, and it apparently had real resonance at the time. And then it wouldn't have taken anything for a reporter, because that's what the prosecutor put out, that's what the police put out, to take a look or talk to someone in the family. It turns out he didn't inherit a dime till he was 30. So what was he supposed to do for those 13 years? It was just like kind of an obvious thing that everyone just accepted the word of the prosecutor. And I'm finding, what, Jim?
How do you know that Tankleff, that Marty knew about the will?
Oh, because there was evidence that he knew. He absolutely, everyone knew in this family he was aware of it. There are so many times also, statements, witness statements. We really found this with the Ferguson case. Oftentimes witnesses don't sign the statements. But, police say, they said this to me, they said this to me. I now, on every one of these, I question every statement, because we're finding out is even well-intentioned cops make mistakes in these statements, and when you go back, they can be really vital differences. In the Ferguson case, I'm not sure they were well-intentioned. Because there were so many problems with every single witness statement, and then if you start seeing that one after another, you're probably going to find a lot better stuff than that. You start with those witness statements, and you start finding, like as Alex said, you track down some of these witnesses, they're going to tell you, they're going to say, well, the police didn't want to hear me say that. In the Erickson case, one of the reasons why Ryan Ferguson was convicted because Chuck Erickson said they committed, he dreamt about it, and then they went out and committed this crime, And the jury all said, come on, Chuck Erickson is willing to go to prison for 15 years? Obviously they did it. Why would he lie? Well, we didn't find out till later, but there was a whole medical report, that's why it took a while for us to get it on Chuck, that even at age 17, he had been using drugs so long he was having these blackouts, and he would do bad things every time he'd have a blackout, so much that he was known among his friends as Fuck Up Chuck. So when he read this article about this crime and he knew he was in the neighborhood, he thought, maybe we did do it. And he started dreaming about it because he was always doing bad things. None of that. We didn't know any of that till afterwards. If I'd known that at the trial, oh my gosh, but you know, a lot of those things come out and then it all just makes it clear. The bottom line is such a simple thing that we just have to be we have to be the skeptical people we always are, and maybe more so with the prosecution than we are with the defense. That's what presumption of innocence means, and it even means it afterwards. I mean, it's just that simple.
Okay, so we have 10 minutes left, and I would invite the audience to come up. There's a microphone there. We're being recorded, so if you would please use the microphone, that would be helpful.
I was just curious, if you had to write like a 40,000-foot story on this topic, what have you learned from doing these kinds of stories? Is there something that ties them all together? Or what do you think about the criminal justice system and how all this gets handled?
Is this directed to anybody in particular?
No,
okay.
no. Up for grabs.
Well, both of you guys can talk.
I'm going to think for a moment. Would you like to start?
One thing that strikes me in looking at these cases is the ability of humans to make mistakes on all sides. And I'm not saying just the prosecutors or the police, I'm talking about everybody. It's remarkable how, we've talked about witnesses, they can be this far away from the crime occurring, literally, and get it wrong. There's some famous cases and books that have been written about that. Not only what we see, but our memory. What we think we remember often isn't correct, isn't right, because our memory is malleable. It changes. And it's remarkable also to me how easy it is to get convicted based on perhaps one witness, one expert witness, whether you pick a jury trial or bench trial, whether you have the resources financially to get the kind of representation that will afford investigators and other resources to help your case. That's one thing I think that cuts across a lot of the cases that we see there. And I think also recently the Northwestern Center on Wrongful Convictions just came out with a exoneration registry, which I think was fascinating. They're looking at all the known exonerations in the United States, and they've learned a number of things from what they've gathered, how African Americans are often the ones who are wrongfully convicted, a lot of patterns like that. And so I don't know if that's helpful, but looking at from the big picture, there's a great deal of flaws in the system.
I'd add two more things too. One is, it's close to Alex, I wouldn't make mistakes. We rarely find a really bad guy in any of this. What I often run into are these cops who believe that they have gut, and then they follow that gut and they wear blinders. There's only been one real investigator that was just, and unfortunately he's dead, this investigator who worked on the John Benet Ramsey case, who always just followed the evidence. I mean, he would be great for any reporter as well as any cop. You follow the evidence, don't go with your gut, don't go by what you... But what we run into all the time are these cops who get this gut feeling and they ignore evidence that's exonerating and only point to what makes them look guilty. And then the other, this is a weird thing, often the defendants are odd. They are. I mean, honestly, they either, when they take the stand, they don't show emotion, they don't act the way we want them to act. And when I say we, I'm talking about the jury, too. So what happens, I would say 9 out of 10 cases that I work on that looks like wrongfully convicted, wrongfully accused, they were odd. And so that's another thing that sometimes you take, when you're working on a story, the defendant might not be even someone you particularly like. You want to like these people, but you have to stick with the facts and just know it's going to be a great story, because that person wouldn't be either convicted or wouldn't be accused if they were perfect. They just wouldn't be.
Again, on kind of the same line, not only do people make mistakes, but people are human. They have their own biases. And it's not just the police that kind of have blinders, that they think they found the right person and they're ignoring everything else. But it goes, into the courtroom with the judge and the prosecutor, where I question the presumption of innocence to a really large degree, and that goes to the jury too. Those are people that, have a job that they're taking time out of their lives for, and they want to get back to. They want to go, maybe they're getting married and have to go on their honeymoon. That's a specific example. They will deliberate for days, and then just someone doesn't want to deal with it anymore. So people are human, and they have their own lives and have their own biases, and it affects people's lives, unfortunately.
Go ahead.
Yeah, the answer to this question is simply, it's a case-by-case basis. Let's not waste any time, and I'll just sit down and maybe ask someone later. But I actually got an email on the way to the conference. I was reading it on the plane, and it just wrenched me. I've been thinking about it for days. It was from a family who, their son, where they were told by the police in another state, took his life, and they have reason to believe that he was murdered. And I won't go into any more detail than that, but I guess my question is for any of you, whether it's a case like that or a wrongful conviction case, we all have so many tips and so many stories to look into. What's the threshold early on to know, is this something I continue to invest my time in or not? And is there one? Because I'm going to have to go to Tennessee and sniff around, but is it worth the time? Is it worth the expense? How do you gauge it?
Oh, I don't have a great answer on this. This one worries me because I'm always worried that I've lost good stories. Sometimes it's by how clearly it's written. When I get letters and it's not clear, I'll say to somebody, I need the facts. Just put it down to one page so then I can get the rest. That's really hard because I think everyone, journalists in this room, is worried we have missed something good. So, making one or two calls, ask for, like if somebody's been accused of something, call his lawyer, just to get a sense that there's really something. But we're all in that same boat.
That's a really good question. Before I was at the Washington Post, I worked at the Wall Street Journal, and we were all competing, to get on the front page. And when I worked there were only basically 3 slots on the front page with a bunch of, carnivorous reporters. So the rule of thumb to answer your question was to do about 20% of the reporting before you walked into your editor's office, because I made the mistake of walking into my editor's office, having done almost no reporting, and he just ate me alive. And I never did that again. But so what I learned from that was, do about 20% of the reporting, because then you know if there's something there. You've done enough reporting that there's a foundation to that story. It does require that you've got to start interviewing people, you've got to pull documents, but it gives you confidence when you go in there that you've got something. That was the rule of thumb.
I have a question for Aaron. I can totally relate to what you said. I'm 2 years into a case in Detroit. 2 guys in prison for murder. The case is incredibly flawed. Brady violations, police misconduct, missed the obvious suspect. The Michigan Innocence Clinic is in, the Wisconsin Innocence Project is in, yet they keep going back to the same judge who found one of the defendants guilty. He rejects every appeal out of hand. That's very frustrating, but I can't get out. My question for you is, do you see any ethical issue with a reporter exchanging or sharing information with lawyers from an Innocence Project or an Innocence Clinic? Something that you wouldn't put on the air? Because I kind of figure we're both looking at the same thing, and if I find something that implicates the guys, that's going on TV too.
Yeah, you raise a really important question that we deal with all the time. Example, like on the Ferguson case, Kathleen Zellner came because she saw our hour. So we talk to her all the time. I find that I tend to expect her to tell me everything, but we don't pass on everything to her. It is a very complicated thing, and I think you have to remind yourself all the time. There's two problems. One is attorneys aren't often interested in the same thing we are. They are looking for flaws in the system, mistakes done at trial, appealable issues that we may not be as interested in because it doesn't make any sense to the audience. It doesn't say whether the person's innocent or guilty. It'll just say they didn't get a good conviction. So that can be a problem, that we're actually looking at different things. But you're absolutely right. Are you obligated then? You get so far into the case and you find out, oh my gosh, maybe this guy really did do it. Look at this. We found, and you're obligated to report it. I would not probably, as a journalist, feel obligated to give it to the attorney. Although I will say, I guess it depends on what your relationship is. There was one time we came on to a story on a guy, his name's Matt Baker, and he was accused of killing his wife. And I trust his defense attorney. He's this great lawyer who asked us to come and do the story. He lets us interview him before trial. Even then I had bad feelings about it, but we interview him. Again, my rule is people are odd. That's why they're being charged. So I let those feelings go. When we started doing work on it, we realized he killed his wife. And in that case, because I had come on and had given him the impression we were going to do a case, I went in and I said, Greg, we think he's probably, this is not going to go the way we said. We're still going to report on it. You can, stop it. You could say we can't talk to your client anymore. But we actually did go and tell him. And just the bottom line of that was, why I was glad I did it, was they used my interview at trial, and he's sitting in prison for 50 years now for killing his wife. So, you always have to remember it. It is an uncomfortable, I don't have a simple answer. It's a very uncomfortable relationship because you both seem to have the same common interests, but you really have to
If I could just follow up a bit. I found someone who I think has information and wouldn't give it to me. They said, do you mind giving me the name so our students could make a run at him? And I didn't see any harm in it. I passed the name along.
I would do that, because then you might still get the information and
get the story.
Yes.
I'm sorry. I wish we had more time. We could talk about this for hours. I want to thank our panelists and thank you all for coming.
Little man, do it fast.
I don't know if this can be done fast.
She's my boss. I gotta go with her.
But I'm interested in getting your thoughts on this, and if we have to do it afterwards, fine. I work in the realm of financial crime, white-collar crime. There's no DNA. There's not eyewitnesses. They're generally federal cases, not state cases, but there's the same mentality among the investigators and the prosecutors that you're dealing with in the cases that you're dealing with. Is it possible to prove innocence in those types of things? And how would you approach it? Are there principles that apply that you do in violent crime cases that I can apply in white-collar cases?
Is that directed to?
Anybody that wants to tackle it in 30 seconds.
If it ends up, some of those cases are so complex, and it's one person's word against another, but aren't still the basic things about the same, that, witnesses may have been pressured? I guess I would find out.
Yeah.
So to me, what we find so often are that witnesses are pressured to give a certain kind of testimony. Can you absolutely prove innocence in that case? Probably not going to be that clear-cut, like to find someone else who committed the fraud. It's whether he did it or not. But you certainly could raise questions about the conviction. Again, you'd have to be specific about the case, but those would be really difficult. But I think basically the principles are the same. There's people who testify against them. Why did they testify? How accurate was their testimony? What about the experts? What are the backgrounds of the experts? Are they really experts? You know, those kind of things. I think they're the same kind of principles. What do you think?
Quick, good.
Quick.
We want to encourage more people to do these kinds of investigations.
I'll be as quick as I can. I recently published a story in the New York Daily News about a woman who was wrongfully arrested for a baby shaking murder of her infant child. She sat at Rikers Island for 18 months without trial. And then I went on a short vacation and came back and found out that she had taken a plea. So it kind of took the wind out of my sails in terms of investigating the story a little bit. I was wondering if you guys have ever run into a situation where you're working on a case where the person in prison has taken a plea. They haven't been convicted. They've never actually had a trial, but you know they're innocent and they're in prison and you can't sleep.
I would have to say to you, you don't need to stop doing this story. And, I mean, if you really believe in the shaken baby, there are tons of stories out there now that indicate that the science, there have been people who have been released when it's later been turned out. I still think I would do it. And if a good attorney sees it, or an Innocence Project decides to take it on, I'd continue with that story. I can't remember all the facts with that case, but I remember your story on it. Greg and I worked on a case, that was the Lister case, where he took a plea, and actually that haunted me during the story because he actually was willing to take a plea. We got beyond it a bit, but it still worries me that he was willing. So I wouldn't stop. I mean, if you believe in this woman and really think that, because there's tons of science now out there that people have been convicted of shaken baby.
I think I can still do the stories. You know, I'm mostly wondering about, you know, in terms of, I feel like with stories like this, you need that other thrust of legal representation. And at this point, I don't know how that works. Like, this is something that I've never seen before. Is that, you know, like when someone taking a plea to a crime that they, you know, it's very apparent that they didn't commit it. So I guess what I'm asking is sort of like, as the journalist, do you feel like you need a lawyer advocate as well? Can you just work on these stories when nobody else seems to care?
We can't often. That's a problem for us. I don't know about you guys, but
I think we have a duty to do the stories when people don't care. We're looking at a shaken baby case too. As you know, it's actually a huge issue, as Aaron pointed out.
Massive. I mean, the more I look into it, the bigger it gets.
Right. So my view is that the role of the journalist is actually quite different than that of the attorney, who by definition is an advocate. We're searching for the truth. You're trying to figure out what happened. And pursuing that seems completely independent of the legal process, in my view. I mean, you can really dig into that. I mean, it'd be one heck of a story if it turned out, for instance, that she took a plea knowing that she was innocent. That's not a bad story.
No, it's not.
I mean, you can get an expert, too, to look at the medical tests that were done, because, I mean, I'm going to go back to the numbers. That I think a quarter of the DNA cases, somebody confessed or pled guilty or made some other type of statement that inculpated themselves, but they didn't do it. So, I mean, there's tons of data on it showing that people will do this to avoid the death penalty or to avoid 50 years in prison. And you just have to get somebody to do that.
better still.
All right, cool. Thanks.
Thank you very much.